Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Before approaching the topic, it is our strong belief and faith in the preamble, that preamble our unity, preamble our identity, preamble our goal, preamble our soul. Therefore, I request each one of you to recite preamble along with me with a sense of commitment, with a sense of sentiment. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So the topic for today is professional misconduct. That is our lecture number 30, professional misconduct and its consequences. First and foremost, let us ask ourselves, our profession is considered to be a noble profession. Our profession is considered to be a learned profession. Why? Reason is, generally it is said, medical profession, the doctors, they save their life of others. We surrender ourselves in a hospital. When you go to the hospital, we surrender ourselves. My Lord, take care of us. Likewise, their patient become an innocent person. He surrenders before the doctor. Likewise, even in our profession, even he may be a literate person, he may be a doctorate in other field, in geography or history. When he comes to the lawman, he remains as a layman. So he comes to us, he surrenders. My property has been taken away. My relatives are in jail. Please protect them. He is innocent. High Court has gone into this mistake, or I am aggrieved out of this order. Please save my life. So he is pleading, he is crying for justice because he is already wounded by the opponents. Thereafter, enough time has been taken before the trial court and the High Court. He comes to us as a last resort, with the lost hope and faith in the institution. So therefore, dear friends, when somebody surrenders himself, we should see to that his right is protected. And we give our best, because there is no further scope for appeal against the dismissal of the order passed by the Supreme Court. There is no further appeal against the order of the Supreme Court. There may be certain provisions, there may be certain remedies, like SLP is dismissed, then review you can file. Thereafter, curative you can file, but you can exhaust all those remedies in the Supreme Court. So every step, when we take a step in the SLP, you have a right of audience. You can plead before the court. Once that is dismissed, in review we do not have the right of audience. We cannot argue our case in a review matter unless and until the notice is issued. Otherwise, it will be decided within the chamber itself. Similarly, in the curative petition also, it will not come in the open court unless the honorable court is inclined to issue notice. So once you lose your opportunity to plead your case in SLP in open court, that is when you are arguing your case in specially petition, it becomes very difficult. So therefore, dear friends, when you are trying to save somebody's life or somebody's property rights, you are going to save the life or save the family life, matrimonial life, you are playing a vital role because you are part of the administration of justice. It is generally said, you may hold any position, but law is above you. Law is meant to provide justice, and Supreme Court is providing justice, and other courts also certainly, but we are part of the system, we are assisting the court. Therefore, in the wheel of the chariot, wheel of justice in the chariot, we are playing a vital role. So therefore it is a noble profession, and it is a learned profession too. Why it is learned profession? It is not simply because we carry books, notes, pencils, therefore it is a learned profession. A learned profession is something that we learn all those provisions, what is guaranteed under constitution, what is said in another statutes, and then you bring those statutes into the real life. You bring article 21 of the constitution to wipe the tears of the citizens of this country. Therefore, dear friends, it is very, very important that it is a learned profession, because you learned something and you bring whatever you learned to the, you bring the smile of a litigant, you bring life to the litigant. So you transform the theory into a life, a living life. So that is why it is a learned profession. So Advocates Act deals with advocates, Bar Council of India, State Bar Council, and its functions and everything. And they have prescribed about what is the professional standards that is set in for our lawyers. There is section 49 clause 1C, 49 1C of Advocates Act, which empowers the Bar Council of India to frame rules. By virtue of those section 49 1C, the Bar Council of India rules was born. And Bar Council of India, after framing its rules, it has made there is a professional conduct standard has to be maintained. What are those standards? Your duty towards the court, duty towards the client, duty towards your opponent counsel, your colleague. So these are all the duties, and they have expressly said whatever the duties that we have included in these professional standards rules, does it mean that you can do something else what is not stated? So what is expected from a gentleman, whether inside the court or outside the court? You are an officer of the court. So therefore you have to keep these standards high. So when you do not follow those standards, then what is the consequence? When there is no consequence, then there is no fear in us and we can do anything. So there, section 35 of Advocates Act says, when you are indulging in the professional misconduct, the consequence is you may be removed from the role, your license will be taken away, or you will be suspended for a particular years of practice. So they are touching the livelihood, they are touching our reputation, they are taking away our ropes. Therefore we are afraid that we should not indulge. And reprimand also, they can give the warning also. They can dismiss the complaint when somebody files, or they can reprimand, means giving a warning to an advocate not to indulge in professional misconduct, or suspend him from practice, or remove him from the role itself. It depends upon what was his action, whether he is habitual offender, or what is the gravity of his action. Accordingly, it will be taken. So the complaint can be done either by an aggrieved person, or the Bar Council itself can take suo motu when it comes to the knowledge that there is a reason to believe that he has committed a professional misconduct. Notice will be issued to the other side, that is an advocate. So notice will be issued by the disciplinary committee of the State Bar Council asking for his explanation. This is audi alteram partem, complaints of natural justice. So once he is heard, and if the disciplinary committee is satisfied with his response, then they may dismiss the complaint. If they are not satisfied with this reply, then they may reprimand, suspend or remove from his role. Depends upon what is the nature of the allegation also and what is the nature of the reply also. So because of this fear, the advocate refrain from indulging any professional misconduct, because they believe that this robes, it is not only the dress, it is address to our profession. So therefore, dear friends, having gone through this Advocates Act and then rules also, I will specifically say what are those rules. You can take down 49(1)(c) of the Advocates Act. 49, general power of the Bar Council of India to make rules. The Bar Council of India may make rules for discharging its functions under this Act, and in particular such rules may prescribe C, that is the standards of professional conduct and etiquette to be observed by the advocates. This is what 49(1)(c) says. Now coming to chapter 2 of the Bar Council of India rules. I repeat, dear friends, chapter 2 of the Bar Council of India rules, which deals with standards of professional conduct and etiquette. Rules under section 49(1)(c) of the Act, read with the proviso thereto. The preamble is very important. Preamble under chapter 2 is very, very important. It says, an advocate shall, it is not may, it is shall. An advocate shall at all times, it doesn't say that only inside the court you have to behave like this, outside the court you are a normal man. No. An advocate shall at all times comfort himself in a manner befitting his status as an officer of the court. So wherever you are, you remain as an officer of the court, a privileged member of the community. Why it is a privileged member? We know the law, therefore we will not break the law. That is what expected from us. So a privileged member of the community and a gentleman. Gentleman includes gentlewoman also. You cannot say gentleman only. Be bearing in mind that what may be lawful and moral for a person who is not a member of the bar, or for a member of the bar in his non-professional capacity, may still be improper for an advocate. Without prejudice to the generality of the foregoing obligation, an advocate shall fearlessly uphold the interest of his client and in his conduct conform to the rules hereinafter mentioned both in letter and in spirit. The rules hereinafter mentioned contains canons of conduct and etiquette adopted as general guides, yet the specific mention thereof shall not be construed as a denial of the existence of others, equally imperative though not specifically mentioned. So you are an advocate, is a gentleman, and he is considered to be an officer of the court at all times, and he is a privileged member of the community, and he has got certain duties towards the court. Section 1 deals with duty to the court. Section 2 deals with duty to the client, and section 3 duty to opponent. That is very important. And section number 4 duty to colleagues or colleagues. So when you indulge, when you are violating these rules and duties, then you are punished under misconduct, which is provided under section 35, dear friends. See, while understanding the professional misconduct, how many rules, how many sections that we need to read? 49 1C of the Advocates Act, read with chapter 2 of Bar Council of India rules, read with section 35 also, that is punishment of advocate for misconduct, where they say dismiss the complaint, reprimand the advocate, suspend the advocate from practice for such period as it may deem fit, maybe 3 years, maybe 1 year, maybe 2 years. Remove the name of the advocate from the state roll of advocates. So now we have seen this. Now let us put it in practice. That is, in the sense, let us read the case law, how these sections, provisions are interpreted by the honorable judges. There is one interesting case, dear friends. Please note down this. This is a very leading case on this subject. I acknowledge or I appreciate one of my associate, Mr. Tekchand, who helped me in taking this case. 1976, volume 2 Supreme Court cases, page number 291. I repeat, 1976, volume 2 Supreme Court cases, page number 291. The name of the case is the Bar Council of Maharashtra, the Bar Council of Maharashtra versus M for Madras, M.V. Dabolkar and others. I spell the name Dabholkar, Dabolkar and others. First, and I will tell you who are all the honorable judges. Honorable Justice V.R. Krishna Iyer, Honorable Justice R.S. Sarkaria, Honorable Justice A.C. Gupta, and Honorable Justice S. Murtaza Fazal Ali. So what is the case is all about, dear friends? Actually, the facts is very, very pity. Reason is, in the court, what they say is the allegation against the advocates were a group of advocates, they used to stand near the court corridors or near the entrance, somewhere near the lift, they used to stand. And they used to see who is entering inside the court. Whether is he a mighty person, is he a wealthy person, or is he a poor person? They will look and they will see who is coming. Are they coming by car or by rickshaw, whatever, they will have a look. Once they find that a person with potential, the person who is coming, that he is a person with money, then they will approach. A group of lawyers will chase, will run behind that particular person, and they will try to say, we will give you the relief, give us. They literally snatch the brief by soliciting that they will do the best. So the honorable court says, compares that if the medical doctors, if they are going to do with the patient, if a patient is coming, group of doctors, they run there and they try to handle the patient, how pity it is. So in the similar manner, how do you expect a lawyer running to the client, snatching the brief and soliciting your profession, advertising yourself? This is professional misconduct. So that is the reason disciplinary proceedings were initiated against nearly 8 or more than 8 advocates in the state of Maharashtra. And the Bar Council, State Bar Council, has found them guilty of professional misconduct. You cannot advertise or you cannot snatch the brief. That is professional misconduct. You cannot advertise yourself, solicit for brief. So they were found guilty of professional misconduct and they were suspended from practice for a period of 3 years. So just now we have seen section 35, suspension. Number of years depends upon the facts and circumstances. So they have given 3 years suspension. Now who is aggrieved? The lawyers are aggrieved, advocates are aggrieved. Now they prefer an appeal to the appellate disciplinary committee, that is Bar Council of India. Now Bar Council of India is very kind. They have absolved all the lawyers from the guilty of professional misconduct. They have given a clean chit to the to the lawyers, advocates. Now, who is aggrieved? The State Bar Council is aggrieved. They have preferred an appeal to the Supreme Court. Now, the matter comes before the honorable judges. The honorable judges have dealt individually the cases. For some of the advocates, they have found yes, they were guilty of professional misconduct. For some of the lawyers who pleaded that we have only 2 or 3 cases and we are at the advanced age, maybe tomorrow or day after tomorrow we may be leaving the profession itself. So therefore, please grant us pardon us, don't punish us. So similarly, Honorable Supreme Court has found that there are certain evidences were lacking against particular lawyers. So they have also given clean chit to some of the lawyers. But what is important here is the law that was evolved by the Honorable Supreme Court with respect to the professional misconduct is. So let us read that, dear friends, because Honorable Justice V.R. Krishna here has authored this judgment and he has beautifully explained each and every aspect. This is how it starts. The judgment of the court was delivered by Honorable Justice Krishna Iyer. These appeals have filled us as much with deep sorrow as with pained surprise. The story of the alleged professional misconduct and the insensitivity of the disciplinary authority to aberrant professional conduct have been the source of our distress, as we will presently explain after unfurling the factual canvas first. The first chapter of the litigation in this court related to the standing of the State Bar Council to appeal to this court under Section 38 of the Advocates Act 1961 against an appellate decision of the disciplinary tribunal appointed by the Bar Council of India. Dear friends, I am not reading what is the facts because they indulge in physical fight, undercut fees they have solicited, and it has brought disrepute to our legal profession. In one case, how an advocate pleaded before the Supreme Court. There are individual cases. I will read out since the cause title says Dabolkar, what did Mr. Dabolkar has asked or prayed before the Honorable Supreme Court. Moreover, he was a senior public prosecutor. We also record the fact that he expressed distress as the arguments moved on. Apart from the weak and mixed evidence against him, there is the circumstance that he is around 68 years old. With a ring of truth, he submitted that he was too old to continue his practice in the profession and had resolved to retire into the sequestered vale of life. He frankly admitted that even apart from the evidence, if there were any sins of the past, he would not pursue the path of professional impropriety hereafter, having decided virtually to step out of the bar, except for a limited purpose. So he says, I will be leaving the profession, but he says there is some limited purpose. He had just 4 cases left with him, which he decided to complete. Having received fees, he has received the fees, 4 cases are pending, therefore let me continue with these 4 cases. He further represented that he did not intend to accept any new briefs or appear in any court except to the little extent that the Bombay Paints and Allied Products Limited, a large company which occasionally engaged him in small cases, chose to brief him. We are inclined, that means the Honorable Supreme Court having accepted his plea, we are inclined to take him at his word. See, this is what the respect to the legal fraternity, dear friends. Though you are called for a professional misconduct, they are not, the Honorable Supreme Court did not go into the veracity of his submissions, whether does he going to leave his profession or whether he is going to handle or accept all the briefs, or he is going to deal only with the limited briefs. Nothing they have stated. What they have stated is, we are inclined to take him at his word, particularly he has put himself out of harm's way by a clear assurance about his future plans. On the evidence, we exonerate him from professional misconduct, and otherwise we record his solemn statement to the court. So individually they have dealt, and ultimately they have dealt with the law is concerned. That is at para 15. We can note down para 15 of this judgment. Now to the legal issue bearing on canons of professional conduct, the rule of law. See how he beautifully says, Lordship, how he beautifully puts forth. The rule of law cannot be built on the ruins of democracy. You ruin the people and then you cannot say rule of law. The rule of law cannot be built on the ruins of democracy, for where law ends, tyranny begins. If such be the keynote thought for the very survival of a republic, the integral bond between the lawyer and the public is unbreakable, and the vital role of the lawyer depends upon his probity and professional lifestyle. Be it remembered that the central function of the legal profession is to promote the administration of justice. This is very, very important. The entire system, judicial system, and the lawyers, we are all here to administer the justice, to assist the honorable court to administer the justice. It is, if the practice of law is thus a public utility of great implications and a monopoly is statutorily granted by the nation, it obligates the lawyer to observe scrupulously those norms which make him worthy of the confidence of the community in him as a vehicle of justice. So lawyer is the vehicle of justice. Social justice, that is where the preamble also says, justice, social, economic and political. The bar cannot behave with doubtful scruples or strive to thrive on litigation. Canons of conduct cannot be crystallized into rigid rules, but felt by the collective conscience of the practitioners as right. This is very important, dear friends. What we have read, the duties towards the court, client, it should not only remain in the rule book, it should be in our conscience. It should always remind us as a heartbeat. So, and they have extracted Rule 36 of the Bar Council of India on standards of professional conduct and etiquette. An advocate shall not solicit work or advertise either directly or indirectly, whether by circular, advertisements, touts, personal communications, interviews not warranted by personal relations, furnishing newspaper comments, or procuring his photograph to be published in connection with cases in which he has been engaged or concerned. So likewise, they have dealt with everything and they have discussed. And finally, we wish to put beyond cavil the new call to the lawyer in the economic order. So they are reminding the lawyer's duty in the days ahead. Now legal aid to the poor and the weak, legal aid to the poor and the weak, public interest litigation and other rule of law responsibilities will demand a whole range of responses from the bar or organized social groups with lawyer members. Indeed, the hope of democracy is the dynamism of the new frontiersman of the law in this developing area, and what we have observed against solicitation and alleged profit-making vices or distant from such free service to the community in the rural sector as part of the professions traced with the people of India. It is a misfortune that a disciplinary body of a dimensionally great and growing public utility profession has lost its vision, blinkered by Rule 36. For the practice of law with expanding activist horizons, professional ethics cannot be contained in the Bar Council rule, nor in traditional cant in the books, but in the new canons of conscience, which will command the members of the calling of justice to obey rules of morality and utility clear in the crystallized case law and concrete when tested on the qualms of high norms, simple enough in given situations, though involved when expressed in a single sentence. We but touch upon this call to the calling of law, as more is not necessary in the facts of these cases. So from this, what you have studied in this case is, we must always remember our rules, and this Supreme Court or the Bar Council of India rules should not only be there in the rule book, but also should be there in the conscience. And ultimately, the administration of justice is very important, and advocates are the vehicle of justice. So therefore, we should always maintain the professional standards as expected from us. So it is a learned profession and a noble profession, and it will remain as noble when the lawyers turns out to be noble and learned. Thank you so much, dear friends, for your patience hearing. I'm really honored once again. Thank you.